Hello, everyone, and welcome to Daily Newspaper Analysis, which is brought to you by LawSeco. Today, we have very interesting articles for our discussion. The first one is from the Hindu newspaper, which is titled as In India, Looking Beyond the Binary to a Spectrum. This is a very beautiful article which talks about giving the right to marry to the homosexual couples and why is this right necessary if at all we want to give a full-fledged right and a real right to them to be in love with each other as well. The second article is from the Indian Express, which is titled as How Poll Results Are Challenged and When Courts Have Set Them Aside. This article talks about the only right which is available to the candidates and the voters whenever he or she believes that there has been some problem with the election polling. And what is this right and what powers do the people, the candidates, and even the courts have in this direction have been discussed in this article. So this newspaper analysis is presented to you by me. My name is Sheva and I am a law graduate, and here at LawSeco, I'm working as current affairs expert and manager for free content. With this, let's see what is the multiple choice question from yesterday's discussion. Unlawful Activities Prevention Act was originally brought in the year. Your options are 1987, 1984, 1956, or 1967. If you know the answer, you can put it down in the comment section below. This is a descriptive question for the day. What is the status of same-sex marriages in India? What steps can be taken in this direction? This is a very good question. Do attempt it writing within a word limit of 250 to 300 words. Also, if you wish to download the PDF of today's slides or you want to avail yourself with various other kinds of study materials like monthly newsletters from the current affairs monthly quizzes, notes, notifications, etc., definitely join our Telegram channel. The link to this channel is given in the description box below, or you can simply scan this QR code that you can see on your screens right now. Also, please do not forget to follow LawSeco, Judiciary, CLAT Prep, as well as UGC channels on Instagram for never missing an update and availing amazing content from here. Let's begin our discussion for the day, which talks about the marriage rights of same-sex couples. So recently, the matter regarding the same-sex marriages before the Delhi High Court was adjourned as the Solicitor General of India stated it not to be urgent in the context of the second wave of COVID-19. Now, here there could be different contentions regarding this because, first of all, decriminalizing the homosexuality in the country by striking down Section 377 of the Indian Penal Code was itself a very alarming and a very, it was basically a two-way judgment where on the one side, the people who support the pride groups, as in who are there in the pride parades, be it the people who are straight or be it the people who are from the LGBTQIA community, they were really, really happy about it because it was something that was considered to be a basic human right and it was not being given to these people. And that is why it was very, very bizarre when at one place we talk about giving the human rights and at the other, we did not even consider the homosexuals to be as equal as the other people are. But on the other hand, obviously there are a lot of people in our country who are very, very, they are very homophobic basically, and they do not understand the concept of homosexuality. Also, there are various kinds of myths attached to it in our previous discussion also, guys. If you have been following us since then, you must remember that we had been discussing about various myths also that people have related to the homosexuality, like maybe this is a disease, this can be cured, this is a kind of hormonal imbalance, we can get it treated by the doctor. And if you know that very recently there was another celebrated judgment which came from the Madras High Court, wherein the High Court stated that if at all we believe that homosexuality is a disease and we try to take that person for any kind of cure to a so-called doctor, then this itself would be a punishable offense, because definitely we need to understand that this is no any disease. Now, the second myth also, which is very much common and commonly accepted and told in India, is that this is something that has come from the Western culture, and we as Indians, being so cultural, being so sanskari, had nothing to do with homosexuality, but rather it came from the Western cultures, and all it has polluted the rich heritage and culture of India. That is something I would call that very unread, and lack of knowledge would be a reason for such a statement, because instances and incidences of homosexuality have been traced from various past activities, past incidents, and historical events as well in the country. So if at all we say that this has come from the Western culture, this would be absolutely wrong to say. So on that note, let's start our discussion, wherein now the Delhi High Court has recently adjourned because the Solicitor General of India has said that currently, when we are going through the second wave of this pandemic, the same sex marriages, or considering the same sex marriages and giving this right to the people who are looking for it, it's not that urgent. But yet again, I think this will be a very narrow statement to say, because if at all we have given them the right to stay together and to fall in love, I think it would completely make sense that now they are given the right to marry as well. Otherwise, there will be no point. See, I always give this example that when we talk about being secular in our constitution, that there is no bar that any person belonging to any religion can marry another, man or a woman. Yes, say, please consider man or a woman from another religion. So that is not something that just we are saying under secularism, but for that we also have a special marriage act, which means that we're not only saying that you can marry another person from any religion, rather we're also making sure that we have a legal backing so that this can be done. Similarly, if we have decriminalized homosexuality by putting down Section 377 of the Indian Penal Code, it does not make sense if we are giving them no right to marry. So this will definitely be something that only exists in the theory or in the literature itself, and we are giving no practical wings to it. And definitely, this should not be the case. On that note, let's understand that what are the various international jurisprudence that are attached to this issue. So if we talk about the South Africa, in 2005, the Constitutional Court over there held that the legal definition of marriage, that is a union of a man with a woman, it was inconsistent, narrow, and it was very much not in lines with the Constitution of the Republic of South Africa. Then Australia in the year 2007, said that the General Law Reform Act provided equal entitlements for same-sex couples in social security, employment, and taxation. So the United States of America in the year 2015 said that the Supreme Court held over there that the right to marry is a fundamental right, and thus it is guaranteed to everyone, including the same-sex couples. And it also held that the denial of marriage rights is actually grave and continuing harm, serving to the disrespect to the people. And if at all we consider the case for India, so as I just told you, that Madras High Court has moved a step forward in this, but not in the same-sex marriages. But let's see what it had to say earlier on this particular thing. So the Madras High Court in Arun Kumar and Shrija versus IG of registration interpreted the term bride under the Hindu Marriage Act 1955 to include the trans women and intersex persons. So we can definitely say that Madras High Court has been really very much forward, and really has been very much broad-minded when it comes to the understanding of the LGBTQIA community. Then the Supreme Court in the case of Shafeen Jahan versus Ashokan KM and others in the year 2018 held that the right to choose and marry a partner to be a constitutional guaranteed freedom, and marriage lies within the core of zone of privacy. But still, it has not come anyway directly or in a way outrightly for the LGBTQIA community. So if we talk about the expanding scope of marriage, so self-respect marriages in Tamil Nadu was legalized in 1955. Among the Dravidian movement, it has been done away with priest and fire or satpadi, and that is why the exchange of rings and garland or tying of Mangal Sutra is some, now these are not considered to be very very big requisites of the marriage, and thus they have moved forward in this direction. Let's see the second article of the day, which talks about challenges of the poll results. So recently, Chief Minister of West Bengal, Mamata Banerjee, has filed an election petition in Calcutta High Court challenging the election result of Nandigram polls. Now, as we know, that though Mamata Banerjee had won the majority in West Bengal elections, as in her party had won the majority, but surprisingly, she from her own constituency, that was Nandigram, had lost. Though some other constituency had to be put vacant, and then she definitely moved in to gain the confidence for becoming the chief minister. But for that regard, she has put this election result on a challenge in the Calcutta High Court, specifically the results of the Nandigram polls. So if we talk about the petitions against the election, so this is the only legal remedy which is available to a voter or a candidate who believes that there has been any kind of malpractice in an election. So what they do is that they submit the application to the High Court of the appropriate state within 45 days from the date of poll results. Okay. And then the matter to be disposed, it has to be disposed within 6 months. So according to the Representation of People Act in 1951. Now, here are these grounds which are mentioned under Section 100 of the Representation of People Act on which any kind of election polls can be challenged. Firstly, on the day, as in the election day, the winning candidate was not qualified to contest. So if that has happened, then you can challenge the election polls. If the winning candidate, his poll agent with candidate's consent has indulged in a corrupt practice. Third, improper acceptance or rejection of nomination papers. Fourth, malpractice in the counting process has done. Or finally, non-compliance with the Constitution or the Representation of People Act. So here, these are the probable consequences which could come forward after this particular election petition. Firstly, it depends on the relief claimed by the petitioner in the petition. Yes, of course, as to what that person is asking. Does that person ask to, what for a re-election or for a recounting, or maybe, for any kind of other kind of investigation or stuff like that? Then Section 84 of the Representation of People Act says that the petitioner may ask the results of all or winning candidate to be declared void. Then the petitioner may also ask the court to declare her or any other candidate as the winner or duly elected. So then again, yes, of course, it depends as to what the petitioner is asking as a relief from the court. Also, if found in favor of the petitioner, it may also result in fresh election or the court announcing a new winner. So here, there have been some previous instances as well. Allahabad High Court in the year 1975 set aside Indira Gandhi's elections from Raebareli constituency on grounds of corrupt practices. And also, the Rajasthan High Court in the year 2008 declared Rajasthan Assembly elections to be void on ground of improper reception of votes. So let's see that what outcome would come in the Nandigram polls in the West Bengal elections. So this was all for the day. We hope it was a good and informative session for you all. Thank you so much for staying tuned with Law Seekho. If you like this session, do give it a thumbs up and do subscribe to our channels. Thank you.